You are the biographer of the late Robert H. Jackson, a favorite of Chief Justice John Roberts, and perhaps one of his role models. In what context did Chief Justice Roberts talk about that?
Well, the Chief Justice has talked about Justice Jackson a number of times in each of his confirmation hearings as a judge appointed to the U.S. Court of Appeals, and as the Chief Justice, he spoke about Jackson. And I think he's obviously in an environment that's very Jackson-educated. Chief Justice Roberts served in the Office of Solicitor General and was in private practice in Washington, D.C., arguing many cases before the U.S. Supreme Court. That's a very Jackson-rich environment, so he has a basis to really know of what he speaks.
One of the reasons I've given previously for admiring Justice Jackson is he was one of the best writers the court has ever had. And I think you didn't have to be a lawyer to pick up one of his opinions and understand exactly what his reasoning is and why he's saying that. And if he's citing and relying on precedents, he can cites them and explains them. They're not written in jargon or legalese, but an educated person whose life, after all, is being affected by these decisions can pick them up and read them, and you don't have to hire a lawyer to tell you what it means.
The Chief Justice and his interpretation of the taxing power and his vote that Congress has the power to pass this law prevented that from happening. And it was a way of stepping the court back out of an issue that is for elected representatives. It was an act of, I think, correct constitutional interpretation, but also good stewardship and statesmanship by the Chief Justice.
One of the principal precedents that everybody was focusing in on was a case called Wickard versus Filburn, a Supreme Court case of which Justice Robert H. Jackson wrote the unanimous opinion for the court. It also dealt with an instance of a farmer from Ohio. We're currently being taped by a Toledo, Ohio public broadcast system station. And maybe you could put that into context, the background of the case itself and ultimately the ruling which led to the conversation before the court the other day.
Well, I think there are three steps that sort of set up why it was relevant to the healthcare situation. The first step is the Great Depression, where desperate poverty, dire economic circumstances pervade the country, including farmers. Farmers are starving because their product can't earn a living profit in the marketplace. The second piece is the legislative response to that situation. Among many, many New Deal laws, the Agricultural Adjustment Act, which had a number of generations, but the 1938 statute, was a system to control supply. And classic standard economics is that demand with less supply produces higher prices, which is a profit, which is a living wage. By controlling the production, in this case of wheat, but of all the different agricultural commodities, the Agriculture Department was creating a market that would be a living survival market for farmers, like Roscoe Filburn was his name. The third piece is the actual litigation. What Roscoe Filburn, and ironically, somewhere in the litigation, the letters got switched, so the case refers to him as Filburn, which we know isn't accurate as a family matter. What Filburn, I'll now call him, does is he exceeds his production quota. His wheat quota for his amount of acreage was a certain amount, and he exceeded that, which resulted in a penalty from the Agriculture Department. And he says, look, you don't have the power to penalize me. You, the federal government, your power is limited to regulating interstate commerce. What I did with this excess wheat was not sell it in the interstate market. I kept it on the farm. I used it for seed. I used it to feed my livestock. I used it to mill and make and bake bread on my own farm. And that's a home-grown, kept-at-home, private, non-commercial, non-interstate activity. The federal government's power doesn't reach this. That's the case that goes to the Supreme Court. That's the case that he loses unanimously. And what the court held was that the power to regulate interstate commerce, of course, is limited in some degrees by political realities, but is a very large sweeping power, has been since Chief Justice Marshall and the classic Gibbons versus Ogden case early in the 19th century. And what it reaches is, of course, literally the channels of interstate commerce, rivers and highways and airports today and so forth. It also reaches articles and actors in interstate commerce. And it also reaches economic activity that has substantial effects on interstate commerce. And what the court said in the Wickard versus Filburn case was, you, Roscoe Filburn, are a small actor. But what you've done is you've kept your demand at home, if you will. The extra wheat you wanted could have been purchased in the marketplace from other farmers. Instead, you kept that demand at home. By withdrawing demand from the interstate market, you don't support the price, you cause the price to drop. That affects the incomes of all farmers. That affects the interstate economy. That's within Congress's power to regulate. And the analogy, which made it part of the healthcare case, is that by keeping healthcare at home, if you will, by going uninsured, people are, in a similar way, externalizing consequences and affecting the interstate market substantially. And just as Congress could regulate Filburn's wheat growing and non-growing, it could regulate and mandate one's uninsured or insurance coverage. What the court ended up doing, 5 justices, Chief Justice Roberts writing for himself and 4 others writing as a quartet together, what they ended up doing is distinguishing Filburn's situation from the healthcare law. They said Filburn is about Congress's power to reach activity, because what Filburn was doing was growing wheat, and that's active, if you will. Whereas the healthcare law was new, went further, reached inactivity because the uninsured are simply not purchasing insurance. It's substantial effects, right, aggregated from very small acts. You know, a Roscoe Filburn is a drop in the ocean, but a whole bunch of Filburns added together start to be economically significant. And once you aggregate individual behavior and have substantial effects in interstate commerce, you're within Congress's power. That's what the Supreme Court says.
As the biographer of Robert Jackson, and we've already noted that Roberts has described Jackson as a role model, it's also been described, the jurisprudence of Robert Jackson, as being pragmatic.
Yeah, pragmatic and restrained. I think what the court did in the Sebelius case, what Chief Justice Roberts, as the decisive vote, did, was a kind of judicial restraint, classic deference, let the political process go forward in sort of good faith interpretations of what its powers are, and let the voters in the political process then decide whether they like it or not. It is a very Jacksonian kind of thing. The tax power is something that the Supreme Court long ago interpreted in a sort of narrow and grudging way. And then in the 1940s and the 1950s, the Supreme Court largely got out of the business of second-guessing Congress's exercise of the tax power, because there's not a very good, manageable, clear standard for justices to impose to say this one's a tax and this one isn't, and this one is 60% like the one that is, so it is too, and this one is only 45% like the one that is, so it isn't. I mean, you get into this process of judicial micromanaging in the name of the Constitution that's not very successful or stable and is better left to elected representatives. Robert Jackson and the court he served on in the 1950s upheld a tax case called United States versus Carragher, which was about a tax on bookies. What it really was an effort to control interstate gambling and organized crime by requiring people to report their gambling income and to identify their profession as bookie. Now, yes, that's a revenue-generating event. It also has regulatory, penalty, behavior-shaping consequences. The Supreme Court basically said, if we could think of a way to draw a manageable line, we might, but we can't, so we won't presume to. We defer. We'll be restrained. We don't run this country. And that view of the taxing power is, I think, an ancestor of the Roberts argument. Of course, he cites the Carragher case in the recent decision.